Hello, everyone, and welcome back to our podcast. I'm glad you could join me today for an important discussion that could affect any one of us. Today, we're talking about premises liability for slip and fall accidents here in North Carolina. We've all been to places like grocery stores, shopping malls, or even walked along city sidewalks without giving much thought to our safety. But accidents can happen when we least expect them, and understanding who is responsible can be a bit tricky. So today, I want to unpack the responsibilities of property owners, both private and public, for injuries that occur on their premises. Let's start by talking about premises liability. In simple terms, premises liability refers to the legal responsibility that property owners and occupiers have to ensure their property is reasonably safe. Like wet floors, uneven surfaces, poor lighting, or anything else that could cause someone to if you're injured on someone else's property due to a hazardous condition that the owner knew or should have known about, you may have the right to seek compensation for your injuries. But, as with many legal matters, it's not always straightforward. One crucial aspect to consider is North Carolina's contributory negligence laws. North Carolina is one of the few states that still adheres to the doctrine of contributory negligence. What does that mean for you? Well, under this rule, if you're found to be even 1% at fault for the accident, you could be barred from recovering any compensation. It's a strict standard that can make pursuing a claim more challenging. So, for example, if you were looking at your phone and didn't notice a clearly marked wet floor sign before slipping, a court might find that you share some responsibility for the accident. In such cases, contributory negligence could prevent you from receiving any damages, even if the property owner was mostly at fault for the accident. Now let's delve into accidents that occur on private property, like retail stores or other businesses. Business owners have a duty to maintain a safe environment for their customers. This includes regular inspections to identify and fix potential hazards, proper signage to warn of any dangers, and prompt responses to issues like spills or broken fixtures. Suppose you slip on a puddle in a grocery store aisle because an employee failed to clean up a spill in a reasonable amount of time. In that case, the store may be held liable for your injuries. However, if the hazard was obvious or if you were not paying attention, contributory negligence could come into play. On the other hand, let's consider accidents on city property, such as public spaces and sidewalks. Municipalities are responsible for maintaining public areas and ensuring they are safe for use. If you're injured due to a poorly maintained sidewalk, like a raised slab or a pothole, you might have a claim against the city. However, pursuing a claim and dealing with a private business. There are often specific procedures and shorter time frames, sometimes called notice periods, that you must adhere to when filing a claim against a city or county. Missing these deadlines can result in losing your right to seek compensation altogether. Moreover, governmental entities may have certain immunities that protect them from liability in some situations. It's essential to consult with an attorney who understands these nuances to navigate the process effectively. Now, let's talk about some typical accidents and types of injuries that occur in slip and fall cases. Common scenarios include slipping on wet or oily surfaces, tripping over uneven flooring, stumbling due to poor lighting, or falling because of hidden hazards like a loose rug or electrical cords. Injuries from these accidents can range from minor bruises and sprains to more severe harm like broken bones, head injuries, or spinal cord damage. Even what seems like a simple fall can lead to long-term health issues, especially for older adults. Understanding the types of compensation you might be entitled to is also important. Generally, compensation, often referred to as damages, can cover various aspects. Emergency care, hospital stays, surgeries, medication. If your injury causes you to miss work, you may be compensated for the income you've lost. This can also extend to future earning capacity if you're unable to return to your job or if your ability to work is diminished. Pain and suffering is another category, accounting for the physical pain and emotional distress you've endured as a result of the accident. In rare cases where the property owner's conduct was especially egregious, the court might award punitive damages to punish the wrongdoer and deter similar behavior in the future. Navigating a slip-and-fall claim can be overwhelming, especially when dealing with injuries and recovery. Here are some steps you should consider if you find yourself in such a situation. First, seek immediate medical attention. Your health is paramount, and having a medical professional document your injuries is crucial for any potential claim. Third, document everything. Take photos of the accident scene, your injuries, and any hazards that contributed to your fall. Gather contact information from any witnesses who saw what happened. Fourth, avoid making statements that could be interpreted as admitting fault. Remember North Carolina's contributory negligence laws. Something as simple as saying, "I should have been more careful," could harm your case. Fifth, consult with a knowledgeable attorney. Slip and fall cases can be complex, especially with the contributory negligence standard. An experienced lawyer can assess the specifics of your situation, advise you on the best course of action, and help protect your rights. When it comes to the differences in the claims process between private property and public or city property, timing and procedures are key distinctions. For private property incidents, you typically file a claim with the property owner's insurance company. The process involves investigating the incident, proving negligence, and negotiating a settlement or taking the case to court if necessary. For accidents on city property, the process often requires filing a formal notice of claim within a specific period, sometimes as short as 6 months from the date of the accident. Failing to file this notice on time can bar you from pursuing compensation. Additionally, the standards for proving negligence can be higher when dealing with government entities, and there may be caps on the amount of damages you can recover. It's also worth noting that some public entities have sovereign immunity, which means they can't be sued without their consent. However, many have waived this. Understanding these nuances underscores the importance of seeking legal guidance promptly after an accident. Time is of the essence, and the sooner you act, the better your chances of a successful outcome. In closing, slip and fall accidents can have serious consequences, affecting your health, finances, and overall well-being. Property owners, whether private businesses or public entities, have a responsibility to maintain safe premises. However, North Carolina's contributory negligence laws add a layer of complexity to these cases. If you or a loved one has been injured in a slip and fall accident, don't hesitate to reach out for professional legal advice. An experienced attorney can help and advocate on your behalf. Thank you for joining me today. I hope this discussion has shed light on the intricacies of premises liability and how it applies to slip and fall accidents here in North Carolina. Stay safe out there, and remember, knowledge is power when it comes to protecting your rights. Please subscribe to our podcast for future updates and visit our website at kellamlawfirm.com.